This video series explains your documents and guides you through signing them. You should keep your documents in the same order as received or printed, as they are discussed in the same order. Before getting started, it is worth noting that this presentation discusses notarized documents. This applies to most every document except a will. If a will is part of your documents, please be aware that it must be properly witnessed rather than notarized, and instructions for doing so are covered separately. We begin by reminding you that an unexecuted document will not provide any protection. That is why we strongly recommend that you sign your documents immediately and before going to a notary. Don't be confused about how you sign your name. Unless instructed otherwise, you should sign your name as you normally sign your signature. As you will learn in this presentation, you do not need to sign documents in front of the notary for acknowledgments. Immediately signing your documents is not only more convenient, it has the potential to provide immediate protection. That's because courts can and often do uphold signed but unnotarized documents. Yet there is little chance of that if it is not at least signed. Of course, no one wants the uncertainty of going to court. That is why once you've signed your documents, you should still have them notarized as soon as possible. We'll discuss two types of notary forms. One is the seldom used jurat discussed later. The other is the acknowledgement, which is the most common form of notarization needed for your trust documents, and it looks like this. You'll see that it basically states you personally appeared to the notary, proved who you are, and acknowledged that you signed the document. Notice that form states that you acknowledge signing the document, not that you signed it with the notary, and that's what the law is. Wherever you see this form, usually just after your signature area, you should earmark each of those pages for notarization. Once the acknowledgement form is completed, it should look like this. Be sure that the notary properly completes each part of every acknowledgement, including 1. The county of notarization, 2. Date of notarization, 3. The notary's name, 4. Your name's 5. The notary's signature, and 6. A clear and legible stamp. So again, you do not need to sign in front of the notary for acknowledgments, nor does the date of the document and the date of notarization need to be the same. For example, the document or signing can be dated May 1st, and the date of notarization can be June 1st, or even years later. Unfortunately, some notaries don't understand the rules, so if you encounter one that says they must watch you sign or says the date needs to be the same, tell them to go online and read the official notary handbook from the CA Secretary of State, which clearly states, in an acknowledgement, the signer must personally appear before you and acknowledge that the signer executed the document, not that the signer executed the document in your presence. Further, unlawfully refusing to notarize a document you requested to be notarized is a violation of the duty of a notary. If they still refuse, you should consider reporting them to their superiors and to the Secretary of State, as this willful ignorance causes everyone pointless inconvenience. Once you've signed your documents, you must personally appear before the notary, prove who you are, and acknowledge that you signed the documents. To prove who you are, notaries can only accept a few methods of identification. Most commonly, this is a current non-expired driver's license, passport, DMV ID. If you are unable to furnish acceptable ID, the most common alternative is to bring 2 disinterested persons with acceptable IDs who can identify the signer. Generally, you will have to pay a fee to the notary. Most states set a maximum fee. In California, for example, the current maximum is $15 per notarized signature. Yet that doesn't mean you have to pay that much. Many notaries are willing to negotiate, especially when it involves notarizing multiple signatures. AAA offices also offer discounted notary fees for members. Finally, in some cases, we prepare documents called affidavits, which are generally only needed because someone has passed away. As a rule, affidavits are rarely a part of creating or modifying a trust, so this is a non-issue most of the time. However, if you have documents with the title Affidavit Death of Trustee, or Affidavit Death of Spouse, or Affidavit Death of Joint Tenant, etc., it is important for you to know that such affidavits must be signed in front of a notary. That's because affidavits, which look like this, use a different notary form called a jurat, containing the words "subscribed and sworn before me," meaning you must sign and swear in front of the notary. But again, affidavits are rarely part of creating or modifying a trust, and are most commonly used when someone has passed away. Now on to signing your documents.